5 seconds to go. Start. Therefore, according to the learned counsel for the appellant, in view of serious infirmity in the trial, benefit of doubt deserves to be given to the appellant, and in the alternative, the conviction deserves to be converted to one under section 304 IPC, and sentence deserves to be reduced to the period of imprisonment already undergone. While refuting the submissions made on behalf of the appellant, learned counsel for the respondent state has argued that the circumstantial evidence on record undoubtedly lead to the conclusion of guilt of the appellant, and no case for interference is made out. Learned counsel for the respondent state has emphatically submitted that the fundamental fact remains rather undeniable that the appellant was last person in the company of the deceased children, and is amply established by the deposition of PW1, the attendant at the petrol pump, and PW4 and PW6, the personnel on duty at the water treatment plant. This apart, the fact that the children were in the company of the appellant is established even in the testimony of PW9, wife of the appellant. Learned counsel would submit that there is nothing on record to suggest the presence of any other person with the deceased children at the time and place of occurrence, and the appellant has not shown his presence at any other place or his having parted with the company of the deceased. Learned counsel has further argued that the medical evidence of PW14 leaves nothing to doubt that the cause of death of the victim children had been asphyxia as a result of manual strangulation. Thus, according to the learned counsel, in the given set of circumstances, when the death of the victim children was homicidal in nature, and the appellant rather attempted to project a false narrative that they fell into the canal accidentally, the concurrent findings of his conviction cannot be said to be suffering from any infirmity. Learned counsel has referred to section 106 of the Indian Evidence Act and a decision of this court to submit that in the present case, the appellant, having failed to explain the circumstances which were within his special knowledge, particularly after the prosecution had clearly established the basic facts about the deceased being lastly in the company of the appellant, and that their death was homicidal in nature with manual strangulation, the want of explanation of the appellant definitely provides a strong link in the chain of events. As regards motive, learned counsel for the respondent state has particularly referred to the testimonies of PW7 and PW8 to submit that the facts were clearly established that the relationship between the appellant and his wife were strained, and the reason for such strained relations was the appellant's constant suspicion over the character of his wife, and in turn his doubts on the paternity of the victim boys. Thus, according to the learned counsel, a case of strong motive for killing of the victim children is also established where the appellant suspected them to not be his sons. As regards the plea of unsoundness of mind of the appellant, learned counsel for the respondent state has submitted that such a plea was never raised in the defense or in evidence or in appeal or even in the petition filed before this court. Learned counsel has further submitted that as a matter of legal principle, if previous history of accused person's insanity is revealed, the investigating officer is duty bound to subject him to medical examination and to submit the evidence to the court, and failure to do so may amount to serious infirmity which may lead to benefit of doubt to the accused, but in such cases the onus of producing evidence with respect to the conduct and mental condition is on the accused, and the court is not expected to presume to the contrary. While relying upon a decision of this court in the case of Bapu alias Gujarat Singh versus State of Rajasthan 2007-8 SCC 66, learned counsel has submitted that the plea of unsoundness of mind qua the appellant is untenable, not just owing to the fact that no such plea or evidence was placed during the trial or even before the High Court, but also because the appellant had no previous history of insanity as such. In this regard, learned counsel has referred to the testimony of PW3, the manager of Rehabilitation Center, to the effect that during the period of admission, the appellant's behavior was like an ordinary prudent man, and he was never administered any medicine for mental illness for no such illness having been observed, nor any previous history having been given by his family members. Learned counsel for the respondent state has also submitted that the plea of unsoundness of mind, if at all, could only be raised by the defense to rule out the forming of menstruia, but a case of purported subsequent mental illness cannot be raised to invoke the exceptions of Section 300 IPC. Thus, according to the learned counsel, reference to the treatment of the appellant post-conviction in psychiatry ward because of the complaints of abnormal behavior is of no avail to the appellant. Learned counsel for the respondent state has further submitted that the suggestions to the effect that the appellant might be having requisite knowledge but was lacking an intention to commit the crime remains untenable for the reasons inter alia that the appellant meticulously planned the crime by taking his children to the canal at a time when he was vested with their sole custody in the absence of his wife. He mercilessly strangulated the children one by one, and if at all an opportunity of realization were to be visualized, at least after killing the first child, he had ample time and opportunity to restrain himself and not to kill the other one. Stop.